Good morning, everyone. Welcome to WorkCover Queensland's Common Law webinar, where we will be discussing remote working and COVID-19, two very real issues facing employers in today's world. My name is Hannah Staunton and I will be your host today. Before we get started, I'd like to acknowledge and pay respect to Queensland elders past, present and emerging. We thank the traditional custodians of country throughout Australia for their ongoing custodianship of land, waters and community. If you need to leave a bit earlier today, this session will be recorded and we will send a link to the recording out via email by early next week. It will also be uploaded to WorkCover Queensland's YouTube channel. Please feel free to submit any questions during the webinar using the panel on the right-hand side of your screen. If time permits, which hopefully it will, we will go through the questions with our guest presenter at the end of the session and provide answers to your questions. I'd like to introduce our guest speaker for today's webinar. I'd like to welcome back Damien van Brunschot of DWF in Australia. Some of you may recall, but if not, Damien has previously presented a webinar for WorkCover back in 2019 on the topic of how common law claims are determined. If you'd like to watch Damien in his glory, it's part of our dedicated common law webinar playlist found on WorkCover's YouTube channel. Damien is the Managing Director of DWF in Australia. He's based here in Brisbane and oversees the Australian operation. Damien is a principal lawyer with over 20 years of experience in insurance law and leads DWF's Australian Insurance Group. Damien, thanks very much for the time you've taken to prepare and present today. Before I pass over to Damien, I'd just like to remind our listeners that any advice given or questions answered today by either WorkCover and DWF is general information only and should not be taken as legal advice. I'll now hand over to Damien to start the presentation.
Thank you, Hannah. I appreciate the opportunity to present today. In looking at this topic, COVID and remote working, I was struck by the irony of the fact that I'm presenting because I've been a bit of a dinosaur, to be frank, and I have worked from home. I've been in isolation a couple of times, and to use a classic expression of COVID, I have pivoted. And we've worked from home more often, but I'm a person who has very much enjoyed turning up and attending the workplace. So that's been my story, but it has thrown up some very unique stories for lots of us in our various organisations. In looking at this topic, I thought we'd start by looking at the safety regime, because here I am presenting to a number of you in the employment law context. And you need to examine first and foremost, I guess, the regime that is most important in terms of prosecution. Not that most of you people kindly who attend these sort of seminars won't be prosecuted because you're here and you're educating yourself, but the reality is you need to be alive to this. Now, breach of the safety legislation does not give rise to a civil cause of action. And by that I mean that if you breach the safety legislation, you're liable for prosecution for penalties such as fines and imprisonment in the worst case. But it doesn't give rise to a claim for damages in the civil law, but it is relevant to a court's assessment of whether there is a breach of duty in civil law. But I think it's important if we quickly touch upon that because it goes to the heart of where a workplace begins and ends. Okay, an employer's work health and safety obligations are governed by, in Queensland, the relevant safety legislation, and the obligations do not cease when the worker is undertaking work in a space that is not the usual place of employment. So it doesn't only, of course, confine itself to the workplace. As known, it applies to people working off-site, working from home, etc. The primary duty, and this is important, the primary duty as expressed in the legislation is a duty of care to ensure, as far as reasonably practicable, and I emphasise the words as reasonably practicable, that the workplace is without risk to the health or safety of any person. Now, the word ensure means to make certain. So If you were just ensuring the workplace health and safety and there was a risk that materialised resulting in an injury, there'd almost automatically be found to be a breach, which would make the culpability far too onerous. So what the legislators have done deliberately is looked at the words as far as reasonably practicable, and that really informs the question of whether there'll be a breach of that legislation. It's important to note that this obligation to ensure workplace safety as far as reasonably practicable actually mirrors the common law, and as I touch upon in a later slide, in many senses it's slavishly adopted from the common law. But the common law obligation is expressed differently with some similarities, but the common law obligation is expressed as follows. It's an obligation to take all reasonable measures to alleviate or minimise all foreseeable risks of injury. So as I say in that slide, and you'll see there is a clear overlap between the common law duty of reasonableness and the notion of what is reasonably practicable in the work health and safety environment. And as I said at the outset, workplace is very broadly defined in the safety legislation. It includes any place where a worker goes or is likely to be at work. Moving on, please. Okay, so how does it marry up with the common law? Well, there's a significant overlap, because when the regulator is looking at whether they will found a prosecution action, whether there is an absence of this care or there hasn't been reasonably practicable steps taken to minimise risk, they really assess a number of things. Weight is given to the likelihood of a hazard or risk occurring, that is its probability. So the more probable, the more important it is to take remedial action. But that's not really the end of the question, because some risks are not particularly probable, and in fact they may be considered unlikely. But unfortunately, if they materialise, it may be catastrophic. And so you need to examine also the degree of harm that might result if the hazard or risk is not addressed or considered, and that's an important consideration. And these are all very familiar concepts to lawyers in tort law because they mirror common law considerations. The availability of suitable ways to eliminate or minimise the hazard is also a consideration, and the costs associated with eliminating the hazard or risk is likewise something that's taken into account. The more costly, the more prohibitive, the more it may be argued that it's not required, depending on an assessment of the nature of the risk, its probability and the likely consequences. So if we move on to common law, the next slide, please. All right, those notions very much familiar to us in the common law arena. My job is to defend employers when there's a negligence claim, acting under instructions from work cover. So it's important that when I examine whether there is the breach of a duty of care, I give considerations that are quite akin to what would be considered by a regulator in many respects in addressing the safety from a safety perspective. Slightly different, however, but it's largely, there is a significant overlap. Firstly, we look at whether the risk is foreseeable. Now, that's not a particularly big hurdle. As Justice Callanan said in a case of Cerebus and Kohler, just about every outcome is foreseeable if you've got a suitably pessimistic mind. Despite the fact that I'm a torts lawyer, I am by nature optimistic, so sometimes I don't see risks that others do, but it's not a particularly high hurdle. Is it far-fetched or fanciful? Is it foreseeable? The second question, which is more relevant, is what do you need to do in response to it, which goes to the heart of breach. There's a third point really not on the slide, but equally relevant to common law consideration, and that is what loss, what damage can be causally connected to the breach. But if you look at what I addressed before in the safety considerations, it mirrors a 1980 High Court decision, which is probably one of the leading cases cited in tort law, Wyong and Shirt, where it talks about the obligation of common law, and it's expressed as follows. An assessment of breach of duty turns on the probability of the risk occurring, the gravity of the harm if it does, and the cost and difficulty of taking precautions and any conflicting responsibilities that might occur. And that's really the key question of breach as expressed in common law. Okay, so what I need to say here is, what do you do when you have regard to the requirement that is imposed on you in the safety sphere and on common law. What do? Well, what you need to do practically is a process of risk management. It's an ongoing process. Now, I'm not going to suggest that necessarily if you do this, you're going to be bulletproof, because claims can be made, but it's the best protection that is available to you to try to manage both your safety obligations and the risk that exists of common law in terms of a civil claim. So really, it's a four-stage process to discharge your obligations as best you can. Firstly, identify the hazards. And a lot of you on this call are in the safety departments of various employers. You'll be alive to these considerations. You identify the hazard, you assess the risks, you implement control measures, and you regularly review control measures. So looking at remote working, for example, it's not enough to say, well, I'm just going to identify the hazards associated with my, if you like, core workplace where people regularly attend. You have to identify hazards associated with other places that people regularly attend, including the home environment. You need to assess the risk. To what extent you do that and to how detailed you do that is really a case-by-case basis that you need to give consideration to, and then you implement control measures. It might be a good opportunity at this point to talk to Hannah, because in a professional services firm like DWF and law and accounting, etc., we've obviously had to deal with remote workplaces and work from home. And there has been the importance of an assessment of risk, particularly of the ergonomics of a home workplace. WorkCover, of course, have had similar issues and have put in place what is, I think, a reasonably practicable and not too costly consideration of navigating this risk. So Hannah, over to you in terms of how you navigate work from home.
Yeah,
WorkCover.
Thanks, Damien. I guess need to preface with the fact that WorkCover is a pretty large organisation. We're probably around 1,000 people. Fortunately, we had started branching out and exploring work from home before COVID-19 reared its ugly head. So we did have our policies and procedures in place, but we have refined them over the last couple of years or so. So obviously our team has gone through the risk management process of identifying the hazards and assessing the risks. When it comes to what WorkCover has implemented, we've sort of gone for a broad scope range of control measures. So we have a policy, of course, that's always a paramount for any organisation that addresses work from home. There's, and the policy, I won't go into detail, but it addresses, obviously we're here to talk about safety in the workplace, in workplaces at home, but it also deals about, because you've got to think about a worker's performance at home and things like that. So it covers all areas. Then from that policy, we have a learning module that we have to do each year, or if a new starter starts with us, they have to do their learning module, which basically addresses all the points of the policy. Before any of us employees work from home, we have to come to a written agreement with WorkCover about working from home, and that again addresses the policy about our behaviour from home, our performance from home, our safety from home, about ensuring the privacy of information of our customers at home and things like that. So in our agreement, we also, before we get the green light to work from home, we have to undertake a risk assessment of our workplace at home, and in particular, our workstation setup. So this is pretty onerous, because we also have to take a photograph of our workstation setup and then a photograph of us at our workstation setup. So there's a lot of boxes that we have to tick to ensure that we as employees are safe whilst working from home. And then they've even gone as far as we have a hazard reporting process at WorkCover in the office, which applies to home too. So if we see any hazards at home, we have to report them and have assistance to basically trying to minimise those hazards going forwards. So I guess safety in the office has transpired into safety in the office at home as well for us at WorkCover. we're not saying we're perfect. It is a learning and improvement thing. Obviously, with policies and that, we like to review them intermittently to make sure that we're addressing all the issues.
That's great, Hannah. Thank you for that. I think that goes to the heart of a process that is thorough. I think it'd be interesting to see what a court, say in a claim, if there's alleged negligence, say in the ergonomics or other setup, I think it'd be interesting to see if a court, I would argue that is reasonable in terms of, but it does rely on a self-assessment. And when work from home becomes more common, it'll be interesting to see whether there's a requirement of reasonableness that it involves also an independent, say, check or something along those lines, and to what extent it needs to be followed up and monitored. But I must say, there's aspects of that we've adopted, but I do think that's a comprehensive and well-considered system. Okay, moving on. I'm going to pose the next question, guys, and that is COVID the workers' compensation disruptor? What do I mean by that? Well, what I'm going to look at here is new notions of what constitutes a workplace, and Hannah's touched upon that, because the safety regime extends to beyond to home, for example, and to contractors. But I think also COVID has brought into focus for all of us what is the broader social imperative of workplace, and work covers very much alive to this. In the return to work environment, they know only too well the social purpose and the contribution that workplaces make. And that has to be navigated too in terms of performance and where people work. And of course, giving people flexibility also has to be considered in the context of what we know about the rising awareness and increased awareness in the community and in workplaces about mental health claims. The potential price of isolation needs to be considered, how people interact with each other and how you're going to navigate that as an employer. And we all know that there's a significant increase in mental health claims in the workers' compensation arena, nationally, not just in work cover. And there's also increased costs because the claims are more difficult and they take longer. And of course, COVID isn't new. It's probably hastened some changes, but there's a whole new world of digital engagement and work blurring the lines, particularly in service-related employment. So, for example, when you look at the way the legislation is drafted, if I'm on my Wi-Fi checking emails on a train, going to work, is that really a journey claim? It might happen in a journey, but I'm actually working. And there's so many more examples, particularly in service-related fields and lots of forms of employment where that is very much blurred. And the legislation, of course, was drafted long before there was these technological and social changes. The next thing I point out on that slide is flexible work. I think it's more likely in many fields, like service-related fields particularly, it's a norm, it's not a point of difference. When I started in the law, you know, we talked a lot in glossy brochures about flexible work because understandably you wanted to attract talent and keep talent. And for example, with a diverse workplace, female engagement, etc., you really needed to look squarely at flexibility. But I think across many workplaces, including our own, it's really no longer a point of difference. It's going to be a norm going forward. And this brings me to the point I made that historical workers' compensation legislation predates these technological changes, predates what we're seeing about flexible work arrangements. So the statutory test under Section 32 in Queensland is, does an injury arise from employment? And was employment a significant contributing factor? And so that test has been considered, and the tricky questions that have been posed have been tricky questions about, well, what happens when you're working in remote locations, when you're on a mining site in a donga? What happens when you're at a Christmas party because it's a work-related function, when you're playing a work-related soccer game with a work team? So these are all the traditional concerns that courts have had in the statutory context. When does the workplace begin and end? And I think you'll find now with the continual blurring between home and work in many fields, workplace will continue to be far more broadly defined. As I pointed to, the journey claim, now journeys, let's look at that. They are a worker benefit that Queensland has adopted. So what Queensland says is, join us, do business in Queensland, and your workers get the advantage of a journey claim provision. So they get that coverage to and from work. There is some recovery often against CTP insurers, but we can leave that aside. But it's a worker benefit. Not all schemes have it, Queensland does. And of course, in that example that I gave before, many times that's really historically based on the fact that you're not working in journeys, but there's many occasions where I see people are regularly working, etc., in a journey. So that the whole test under the legislation is very much historical. I mean, the workers' comp legislation dates back to the early 1900s in Queensland. It's now under the 2003 Act. You'd be surprised how little it's actually been changed in that time, considering the lapse of time. So to answer my question, is it the great workers' compensation disruptor? Probably not, in the sense that I don't think we need to see wholesale changes in legislation. But what I do think we will see and will continue to see is a more expansive definition taken of the workplace, consistent with, if you like, the new social norm. Okay, well, let's look at COVID. I know we like to think it's behind us. We know we like to think there is no pandemic, but we're actually still in the heart of it in many ways. It's just fortunate that we're getting on with things. I'll be reasonably quick because I've got a bit of slide to cover, but Safe Work reported that the period covering 1 January 2020 to 30 December 2020. Now, it's some time ago, but remember that that's a very reliable statistic, because that was in the early days of COVID. There were 1,222 COVID-19 related workers' compensation claims lodged across Australia, and approximately 80% were accepted. So why I say that occurred in the early days of COVID is because it's a lot easier in the early days of COVID to establish a point of, if you like, transmission, or that it might have been a workplace contracted disease. And of course, as it's got more prevalent in the community, it's particularly prevalent if you're fortunate enough, like I've been, to have teenage children, for example. It's obviously far more difficult to link it to employment. But in the COVID context, the worker must provide evidence to show that the exposure occurred within the normal work environment, which could include home or travelling to and from work in jurisdictions such as Queensland. So there is a case in which a COVID claim was accepted, actually, that went to court. So it has been tested in the statutory arena. It's quite a sad case in many respects, but it's a New South Wales claim. What happened in that case was an employer was held liable for the death of an employee related to COVID. And in fact, the workers' compensation insurer paid $834,000 to the deceased remaining relatives or spouse in that case. So the employer in that case, it's a case of Sarah v. Sarah, was required to travel to the United States for employment-related purposes. The employer submitted that the employer was undertaking work for the US company, which was a related entity. And it was found by that case by the Commission. In Queensland, it'd be found by the QARC equivalent. But it was held in that case that there was enough evidence to say that the employee contracted the virus during his travel to the US. Sadly, it killed the person, so it was a COVID fatality. And on that basis, the claim was accepted. So there you have an example of a case in which a worker has been able to prove that the virus was transmitted in the work context, in that case, on a plane. Moving on. I touched upon the fact that there is the ever broadening concept of employment, which is less limited to time and place. And another really quite sad case, actually, is a case in the New South Wales arena. Just bear with me and I'll find it. It's actually a domestic violence case. It's very sad, but it just goes to show it's a home-related death, actually. So a couple were working at home in a financial planning business. The female, the wife, was shot by the husband at home, about, hard to say, but between 8 to 10 in the morning. Now, the male husband had severe mental health issues, including paranoia, and was very unwell. He was actually charged with murder, but he went through the mental health system. He wasn't fit to plead. So in that case, the woman received compensation on the basis that it was still a work-related injury, which resulted in her death. The partner's assault was work-related because they were working at home together. It was during the day when she generally worked. And importantly as well, sadly in that case, the perpetrator, if I call him that, the man, was very much paranoid about her work performance and issues around the business in an overall context of mental health. But that was also highly relevant as well to a consideration in that case that there was a causal link. So there you have a case where there was a compensable injury at home in a domestic violence context between both husband and wife and co-workers. I might say, looking at working from home, there are some peculiar difficulties that arise. For example, obviously, when people report an injury at home by themselves, just the practicalities of it in terms of a witness, you don't have people around. So some of the witnessing and other issues make it more difficult practically to counter or contradict any assertion of how an injury occurred. But in cases involving, say, violence, like in that case, you need to look also at the motivation for the attack, and in that case, it was found to be, in some senses, employment related. So that's a case that's worth citing in this context. There's another case that I'll really move on quite briefly, and it's probably not particularly different from other lines of case in Queensland. It's a case of N versus Hydroelectric Corporation, Tasmanian case, where a person was working in a remote location and they were walking their dog with their partner, but they were on call and they got a fractured femur, and they were it was compensable on the basis that although they weren't strictly at work, they were required to be on call, and he was going back to the house so he could get reception because he noticed his phone wasn't able to take reception. He needed to be there on call. And that was found to be a sufficient context of employment. So there's some statutory cases which illustrate the point I was trying to make, which is a more expansive view of employment will be necessarily taken consistent with these social norms. And it is having an effect in the common law arena as well. And there's a vicarious liability case fairly hot off the press that I cite. Now, what's vicarious liability? It's a policy-driven rationale that the negligence of an employee or co-worker is sheeted home to the deep pockets of an employer with insurance. That's really the rationale that underpins it. It's a policy rationale. So employers are vicariously liable for the negligence of a co-worker if it occurs in the course of employment. That's been the traditional test. So for example, if someone's driving a forklift and negligently runs over another co-worker, or there's a traffic accident involving driving in workplaces, all that stuff is generally just vicarious liability. Even if the employer, you don't need to prove necessarily breach. But the cases on the margins have really concerned what constitutes arising in the course of employment. And the case that I cite there, Shockman, is a recent Court of Appeal decision. And that was an interesting case as well, where people were working at Daydream Island. Alcohol was involved. They were in this room together. And one of the men came home very intoxicated, didn't know where the toilet was, and sadly urinated on the head of, in an intoxicated, semi-conscious state, of this claimant, the plaintiff, who brought a claim and sustained a psychiatric injury. Now, at first instance, the court found that there's nothing the employer could have reasonably done to navigate such an unusual and sad risk that materialised in this case. And they also argued in the alternative that there was vicarious liability because there was a sufficient connection between his negligence, the perpetrator, and the employment context. And that was rejected at first instance by His Honour Justice Crowe in the Rockhampton Supreme Court. And it was that latter point, only the vicarious liability point, that went before the Court of Appeal recently. And they overturned the decision and found a very expansive notion of what arises in the course of employment was, and found that there was sufficient connection there between the fact that it was mandated that they stay at this at these premises, mandated for work. They were there only for work, and that was sufficient to for the employer to be held vicariously liable, even though it was accepted that there was no material breach, otherwise a material breach at common law. That case may well go before the High Court on that point. Hopefully the High Court will be sufficiently interested, because I think it is a really important case that goes to the margins of an important principle in tort law. Okay, let's look at the time and where we're at. Okay, 10:31. I'll keep I'll keep moving on. Next slide, please. When I was looking at remote working, I thought maybe I'm a bit blinded by professional services like My Place and WorkCover and a lot of people we work alongside, and because it's really far more broadly defined, obviously, than a work from home environment. We've seen that a lot in COVID, but remote working is not new. Labour hire is a classic case, really, of remote working. The business model is such that you assign someone to work at the host employer or the de facto employer's work site. And we all know in that case that you can't wash your hands of someone. You need to still assess the risks of the host. Now, that might just be enough to say, look at their work. You should go in and have some look, but it might be enough just to satisfy yourself with their workplace generally as well. So that's an important remote working context. Contractors working on another site, mining and construction, that's also common. So going back to the risk assessment slide, there's still a requirement to assess the risk. Now, what constitutes reasonableness is very case specific. So if you're a labour hire employer and you're assigning someone to work at a host and assigning a lot of your people, it's known that they're working there and you know their site and you should make some precautions, even though you're entitled to rely on them at some level. You still have to make some steps to assess their workplace. It might be a bit different, for example, if you're reading meters, if you're, say, an employee goes to a number of residential settings to read meters or do other work, or a plumbing company, for example, you might then have less of an obligation to satisfy yourself of the safety of the premises and the safety of the system of work. But the point I touch upon is there clearly is at common law an onerous obligation to devise, implement and enforce a safe system. Let's look at common law liability for work from home injury. In assessing this topic, I think we ought to take stock of where we have got to broadly in the development of the law in this field. And the point I make there, is there strict liability? Close, but not quite. So what I mean by that is this: putting aside where your people are working, the obligation is to devise, implement and enforce a safe workplace. That involves a system of work, that involves an analysis of plant and equipment, an analysis of risk. It involves, for example, the obligation to provide a level of training and instruction, particularly relevant to, say, manual handling cases involving 3 points of contact. So the courts have been quite quick in many ways to find liability for what would otherwise be considered relatively innocuous events. So there's been liability found, for example, with manual handling of a 12 kg reams of photocopying paper by an administrative worker, albeit in the context of what was then the workplace health and safety legislation, but liability nonetheless. Putting a 5.8 kg wheelie walker into a sedan by a support care worker, the wheelie worker that is often used in the aged care industry, there was also liability for that, despite the fact that that may be a commonplace task if you're caring for, say, your elderly parents in a non-work related setting. So really what we've got to is a very onerous obligation. It's still reasonable care. It's still not a standard of perfection. We know that the law says you don't assess this by reference to hindsight, but we still know that it's a very high standard and it can be quite practically difficult to discharge, particularly in certain areas like manual handling jump out at you as an obvious example. So if you take that framework, if you look at the fact that the obligation is quite high and it's onerous, let's examine where we'll be from a work from home perspective. Just by reference, I can't point you to a case yet other than the cases I've cited in the statutory arena. But if you put it through the lens of basic principle, first of all, let's look at foreseeability. Now that could come into play because if someone's working from home, you need to assess what their work duties and job title are, what they're required to do. So for example, you know, if they're a worker who's required to sit in front of a computer or make phone calls or draft documents, whatever it is. But obviously, there might be some incidental lifting. They need to traverse not only, they might need to traverse, for example, around the home office to go upstairs or downstairs, or depending on where they are, etc. So you do have to examine some level of foreseeability. You don't need to foresee the exact injury, you just need to foresee an injury of the kind. And as I touched upon, it's not a huge hurdle, but it needs to be looked at. And then you look at the question of breach. What is the reasonable standard? Now, if you look at Hannah's example in workplace, I think, for example, in an ergonomic claim, that taking photographs and some assessment, some self-assessment, I would argue that in the context of what is reasonable, that is okay. And it's not. It'd be too. I would argue it'd be too prohibitive and costly to go out and go out with a safety person and do, say, an ergonomic assessment, absent any specific knowledge that you might have. In the absence of specific knowledge, it might be different. But that's my personal view, frankly. And a judge may consider that if it's so probable, and if so many of your workplace workers are at home regularly, and you know that, that it is incumbent upon you actually to take that additional step and to not just rely on a level of self-assessment, say, checked with photographs in, say, an ergonomic case. So there'll be some fertile ground for argument there. And I touched upon, when you look at the Wying and Shirt calculus, or I don't know what, I'm not sure why it's called the calculus, because there's nothing to do with maths, but in any event, that's how lawyers refer to it as. What is the revised probability? Well, that's also a consideration that you need to have. If remote working is a norm, and it is a new norm, it's obviously far more probable that workers will sustain an injury, say, in the home environment, and that's a consideration that you need to have regard to. And then you have to consider, what are the remedial measures? Well, in an ergonomics case, it's assessing the ergonomics, making sure they're safe. But does it involve, to say, an assessment of, say, someone's internal stairways where they're walking up and down, to, say, access the kitchen or access the toilets? Is that too cost prohibitive? Does that cut across the obligation of a homeowner to take reasonable care for their own property, etc.? So what are the remedial measures that can be adopted? And I would suggest for most work from home context, it's really about an assessment of safety of ergonomics, a general safety around, from a safety perspective, ergonomics. Some look at the access, some look at access without being too rigorous. I don't think you need to be too rigorous, but some look at it. And that's probably sufficient. But in most cases, depending, I might say, on the nature of the task they're required to undertake, and depending upon what you know. So you might have some knowledge of, say, a specific vulnerability of a person, a specific issue that they may face in say, or a specific condition, which might mean you have a heightened duty to assess and make sure their workplace is more bespoke, if you like, to them, to minimise your risk. Okay, so that's really the lens with which I think you should look at it. And let me just see where we're at. So we've got 20 minutes, Hannah, for questions. I'm happy to take some. I can't see on this forum how many have been posed, but
that's all right. Look, I might just ask you them on the spot, because I think we've got this covered. Let's stay on the work from home and remote working issue. I guess employers are more after some practical insights. Question coming through: what happens if someone is working from home and slips over whilst going to the bathroom and injures themselves? Is this injury covered?
My view would be yes, in the statutory arena, because as I touched upon, it still arises in the course of employment. You might argue, you might have to look at what the time it was, what were the work-related duties, but if it's a normal incidental part of your work day, which it is, to move around, and the answer would be yes. Would it give rise to common law liability? That would be quite a difficult common law case to run. You would need to look at the nature of the hazard that caused the slip. It's often forgotten that people can slip without any hazard, I might add, but you need to look at the nature of the hazard, to what extent it could or should have been addressed by an employer in a remote working. And I would say that, albeit not impossible, I would say it would be a difficult common law claim to advance, depending on the circumstances.
Yeah, I'm glad you touched on the difference between the statutory claim and the common law claim. That's important when the statutory claim is no fault with a few exceptions in there. Still on the work from home topic, does an employer need to define a workplace at the worker's home to ensure the whole home does not become a workplace?
That's a really interesting question, and I'll be guided a bit by you, Hannah. I would have thought that is too onerous and too prohibitive to address it in that whole context. Most people that I've seen looking at practically discharging their obligation, like the example that you gave in work cover about providing photographs and having a self-assessment, it's really quite limited to the space within which you work. So my view is it would not need to be cast that broadly. I'm not sure if you have.
No, I agree. There's got to be an element of reasonableness to it, but I think it's important to make employers aware that recess claims that happen at work also happen at home. So the courts and work cover are well aware that when we're working from home, you have to have a nature break, you have to have a lunch break, and you're probably going to do things on those breaks similar to what you do on those breaks in the office. So we do take into consideration those things. Yeah. There's so many practical questions coming through. The other question, I just changing topics quickly. COVID-19, obviously it's a big ticket item. Do you think there is potential for a worker to be successful with a common law claim for COVID-19? Just wondered, Damien, if you wanted to break it down firstly into a claim for COVID-19 as an injury, and then the fact that there are some other injuries popping up related to COVID-19, such as psychological injuries and things like that.
That's really, it's a really interesting question. Well, certainly, firstly, you need to overcome the statutory hurdle. So you need to prove that your COVID condition is employment related. And as I touched upon, as the pandemic has changed, as vaccinations have come out, it's far more widespread. I think that will present far more of a practical difficulty than in the early days of COVID, where there were clear contacts and it was a lot more measurable. So the data that I put up about the COVID cases accepted is early days in the pandemic, but I think it's very reliable data because I think in many ways it represents the high watermark of COVID cases that are accepted. So then let's look at common laws. Assuming you've got over the line, you've proven that it's a work-related condition, that it was contracted in a work setting, you would need to establish that the employer failed to discharge its duty of reasonable care. And that may pose a number of real interesting arguments. So, for example, the best you would cite is they failed, for example, with respect to, say, a policy with respect to home quarantine. If they knew or would have known that needs to be implemented and enforced. If, say, a close contact or a person with COVID was in the workplace, did they have sanitisation? The very things that we've confronted in this space would need to be assessed whether it was reasonable. I think it would be a difficult argument for a claimant because it's a very contagious virus. I think it's a lot easier to prove at the statutory level that it's work-related than it would be to prove that there's an absence of reasonable care on the part of the employer that led to it being contracted, because you can just get unlucky. I don't think it's impossible. But I think it would be quite difficult. Remembering, as I touched upon, that although the standard is high in common law, it's still a standard of reasonable care. It's not a standard of perfection. And I think that every case is fact specific. I haven't seen a common law COVID case be advanced, and I think that's because of difficulty. Going to the psychiatric injury claim, interestingly enough, the way the law looks at these cases is psychiatric injuries, if there's no secondary physical injury, say it's just a psychiatric injury, is considered separately from physical injuries. There's a school of thought that they ought not to be, but traditionally they always have been in the development of tort law, because courts have been concerned about the floodgate arguments in psychiatric injury claims. So if there's a psychiatric injury, again, I think that in COVID, I think it would be a relatively significant hurdle to prove that it was foreseeable that someone would decompensate. No, you don't apply the normal fortitude test anymore, but would it be foreseeable that someone would decompensate as a consequence of contracting COVID in the workplace, and also that there was some absence of reasonable care that led to the contraction of COVID? Those are the considerations. So a leading case in that space is a case where a person, a female, read a police report actually that said she was intoxicated and that led to a motor accident. So she read this and she really decompensated because she was a teetotaler, and she thought it was outrageous. And in fact, it was a mistake. It was an administrative error. She wasn't intoxicated, but these things happen in the police system. She brought a claim for a psychiatric injury, and it was rejected on the basis that it wasn't foreseeable that someone would decompensate like that from an administrative error of that ilk. I don't know. I think that's a case at the margins. I think it's COVID and our increasing awareness of mental health. It might well be foreseeable in some circumstances, but I do think proving again that there was an absence of reasonable care that led to the contraction of the disease would probably be the more problematic hurdle in my view.
Yeah, there's also seems to be, well, there is a few claims being made out there in the statutory claim space, that wondering what your thoughts on whether they'll transpire into common law claims where we're receiving claims, statutory claims for psychological injuries or pertaining to COVID-19 mandatory vaccination requirements. Just wondering whether you had any thoughts to share there on whether you think that there would be major hurdles for a claimant to get over.
It's really interesting. That's fascinating. So I'm no employment lawyer, okay, so I'll qualify that. But I know there's some cases in Fair Work Australia about the reasonableness of directions given to mandate, and there's been some cases that I think have been relatively sympathetic to employers actually, because it's been a government mandate. So that's an important consideration. So in that example, I think that it's not impossible again if there's a statutory claim. Now, interestingly, let's look at the statutory claim, the psychological injury test. It may well be captured by reasonable management action in the first place, having regard to the fact that it may be a reasonable direction depending on the employer and what the government mandates. So it mightn't get through the first hurdle because, as Hannah touched upon, statutory claims are no fault. It just requires a connection to employment, with the exception of pure psychiatric claims where there is, if you like, some fault element, which is captured by section 32, subsection 5, the reasonable management action exclusion. So firstly, that's a consideration. And the second consideration in that case is whether the employer acted reasonably and consistent with government guidelines. And I would have thought there'd be some sympathy for an employer in that species of case in the common law arena. You haven't seen them translate as yet to common law claims, Hannah, as I understand it. So anything's possible because, as you know, it's a big industry, personal injuries, and once you have a statutory claim and someone's prepared to take on a novel case on a no-win, no-fee basis, you couldn't rule it out. But I do think it would be a problematic case to advance.
Yeah, I guess all eyes are on the courts to see when and where a first COVID-19 common law claim may come through.
That's right. And I do think that if you look at, say, as again, the cases in the employment law context on whether there's a reasonable direction for, say, vaccination and other requirements, there's been some dissenting voices, but a consistent theme to emerge has been in a position actually very sympathetic to employers having regard to the difficulty of navigating this coupled with government requirements. I'd like to think that would translate in the common law arena, but you watch this space, absolutely.
Yeah, look, we might wrap the questions up there. Thank you everyone who has submitted questions. Damien, thank you very much for your time and preparing today's presentation. We really appreciate it. A big thank you to our listeners today. Thank you for tuning in. We hope you found this session informative. As mentioned earlier, this session is recorded and will be sent out to you early next week and also uploaded to our Work Cover YouTube channel, where you'll find all our previous common law webinars. That's all from us here today at Work Cover. Have a great day. Keep an eye out for the details of our next webinar, which we sent out by an email if you did register for this session. We also advertise on LinkedIn and our WorkSafe website. Thank you and have a great day.